All right, good morning, and thank you for joining us. My name is Andre Bro, and I work on the team at One Acadiana. And welcome everyone to our sixth installment of the Acadiana Business Resource Webinar Series. Our Acadiana Business Resource webinars are brought to you by business resource partners from across the Acadiana region, including One Acadiana, LIDA, Opportunity Machine, the Downtown Development Authority, the Louisiana Small Business Development Center at UL Lafayette, Acadiana Workforce Solutions, the United Way of Acadiana, and other local chambers and economic development offices from around the Acadiana region. We have come together to support Acadiana's business community, particularly our small businesses, in response to COVID-19 by hosting a series of webinars on timely and relevant topics. Today's webinar is presented by Jones Walker and Keaty Real Estate on COVID-19 issues facing landlords and tenants. After the presentation, we will use the remaining time for Q&A. As you have questions for our panelists, please enter them into the Q&A box and select all panelists from the Ask menu. We will be recording the questions as we go. If we do not have time to get to your question during today's webinar, we will try to follow up with you as soon as possible afterwards. Before turning it over to the Jones Walker team to kick off today's presentation, let me say a few words to introduce them. Jones Walker is one of the largest law firms in the United States, serving local, regional, national, and international business interests in a wide range of markets and industries. The firm has more than 350 attorneys throughout 13 offices, with more than 15 attorneys practicing here in Lafayette. The firm has 34 practices, including a large real estate practice. The real estate team advises clients on matters ranging from simple sales and acquisitions to structuring all aspects of large-scale developments, including mixed-use developments, industrial projects, and public projects. Please note that the information described in this program is general in nature and may not apply to your specific situation. Legal advice should be sought before taking action based on the information discussed. Presenting today are members of the Jones Walker Real Estate team, Kyle Bacon, Andy St. Romain, and David Kurth. Kyle Bacon, who serves as head of Jones Walker's office in Lafayette, will kick off the presentation. Kyle, the floor is yours.
Thanks, Andre, and good morning to everyone. Hope everyone is safe and healthy. Little odd to be doing a webinar remotely like this, but this is we appreciate One Acadiana for facilitating this, and hopefully we can share some thoughts with everyone about some of the issues that we're seeing in the real estate world, particularly with regard to leases. One thing I would note is that here in Acadiana, we are accustomed to sort of tumultuous economic times with the oil and gas industry that we've historically been so tied to. We're accustomed to a lot of ups and downs. This one is different, I think, in my view, because it not only affects the oil and gas primarily, but it's much more widespread. It affects, obviously, oil and gas is industry's having a really hard time right now. There's no doubt about that. But it's also affecting directly retail outlets, restaurants, even healthcare industry on non-essential healthcare services. And so, this is an economic downturn that's going to affect a wide range of companies and industries. So what we'll talk about today are concerns and issues that landlord and tenants may face, particularly in the immediate term. I do want to note that we're not going to have time today to cover every issue. I'll focus on some provisions some issues relating to what we call force majeure and impossibility of performance under leases, and then my partners, David Kurth and Andy St. Romain, will talk about issues relating to conflicts under the lease scenario and how to potentially resolve some of those issues. There are a lot of other resources out there, and like I said, we won't have time to go into everything today. There are some federal programs that I think a lot of folks are familiar with or have heard about. The PPP program. There's the EIDL loans that are out there. The part of the PPP can be used to pay for rent payments in some circumstances. And there's also some federally mandated holds on evictions related to mortgages that are federally backed or properties, housing that is federally sponsored housing. So those areas are sort of a little beyond the scope of what we plan to talk to today, just because of time constraints. And so today we'll focus on some other aspects of lease agreements, and we're certainly happy to talk to anyone about some of those other programs offline if someone has specific questions related to those. One of the things that we're seeing is out there is that tenants are struggling with, how do we get rent paid, because we're not able to function as a business like we used to and like we're accustomed to. One of the things that we're seeing is that landlords generally are being pretty accommodating to the extent that they can. And one of the things that Andy and David will talk about is that there are some limitations on what landlords can do from an accommodation standpoint, because a lot of landlords have their own mortgages or loan facilities that they have to pay for, and sometimes and they need that revenue stream, number one, and sometimes those other agreements may directly impact their ability or restrain their ability from granting concessions on rent payments. So with that in mind, what we'll do is, if we can go to the next slide, Andre, we'll talk first about force majeure and impossibility of performance. These are two concepts under Louisiana law, and so the first thing I want to touch on is what are these concepts in general terms. Force majeure is a contractual provision, and so this is a provision that will be found in a lease agreement that excuses a party to a contract from performing all or part of an obligation because an event or circumstance that is beyond his control renders him unable to perform the obligation. So basically, it's a situation where that arises beyond control of the person who's obligated to perform, and it's a provision potentially in the lease agreement that allows the party excuses the party from performance. A lot of times you hear this called act of God provision. There's also a concept under Louisiana Civil Code that excuses performance by an obligor due to what's called a fortuitous event that makes performance impossible. And so, what do we mean when we say performance of an obligation? Well, this could be a rent payment. It could be maintenance and repair obligations for tenants or landlords, or vendors or third parties, service providers that the landlord uses. Are those available and able to provide these services for the leased premises? It could be landlord's obligation to provide access to the common areas. Is the landlord able to do that under current circumstances? It could also be the tenant's obligation to continuously occupy and operate in the premises. Is the tenant able to perform that obligation of continual occupancy? So those are the sorts of things we're talking about today. Go to the next slide, Andre. So what types of documents or agreements do these concepts apply to? They apply really to potentially apply to all real estate and even other documents. You can find these types of provisions of force majeure provision in loan commitments, leases, property management agreements, construction contracts, development agreements, purchase and sale agreements. So this concept could come up in a variety of contexts, and truthfully, it's not just in the real estate world either. It's in all commercial transactions. It's very common to have a force majeure provision that excuses performance. But today we're going to focus on leases, and this concept can be invoked potentially by landlords and tenants. Next slide. So first step is to, if you have a situation where you think you might be not able to perform an obligation under a lease agreement, the first step is to review the lease agreement to determine whether there is a force majeure provision in the lease agreement. And if there is, then the second step is to evaluate whether it applies to the specific situation. Third, if it's determined that the force majeure provision does apply to the specific situation, then consider whether sending a force majeure notice is required under the lease. Next slide. So does the force majeure provision apply? That's step number one. Actually, step number two. Step number one was is there a force majeure provision? Step number two is, does it apply? Key thing here is that every provision is going to be different. So you've got to look at the specific language in the agreement. It's fact specific, which means it's going to depend on the particulars of a situation. And it's the provisions are going to be strictly construed, which means courts are going to read the language very tightly and will apply it only if the situation clearly fits. Now, just because everyone's going under the same COVID-19 situation doesn't mean that this situation is going to apply to every lease party the same way. It's going to depend on the obligations of under their particular lease agreement, and it's going to depend on their particular business and also their particular situation at the lease premises. I've given you an example here of some of the things that a force majeure provision may be stated to apply to. A lot of times you'll see language that it applies in the event of strikes or lockouts, weather conditions, accidents, casualties, acts of God. Usually acts of God are considered natural disasters that applies to. Inability by the exercise of reasonable diligence to obtain supplies, parts, or employees that are necessary. Actions of governmental authorities, riots, insurrections, and other causes beyond the reasonable control of the parties. That's a list of situations that is not uncommon in a force majeure provision. But again, every provision is different. If you notice, there's nothing in this language relating to a pandemic or an epidemic. I think that's something we may see going forward into the future, is that these force majeure provisions are written with something like this in mind. But you do notice that the sample language there does reference actions of government authorities. So we do have certain government mandated closures in place related to video poker establishments, movie theaters, bars, bowling alleys, fitness centers, and gyms. So those by executive order in the state of Louisiana have been mandated to be closed. The question becomes, and because of that government mandated closure, does the force majeure provision apply such that the tenant, for example, is not required to pay rent? Unfortunately, in a lot of leases, there's a carve out usually for rent payment. So you have to look at the particular provision and you have to look at this particular situation. One that might be interesting is takeout or carry out requirements for restaurants. So that's a situation where the restaurant's not required to be closed. It can have takeout or carry out services, but it's probably not doing the business it was when it had in-service seating for its restaurant. So these are question marks in the law right now as to how courts will read these provisions and the situations to which they apply. And again, it will vary from lease to lease and from situation to situation. So next slide. It's important to note that there may be a notice requirement in a force majeure provision. Some force majeure provisions require notice, not all do. If they do, there may be a required timing of the notice. Sometimes it says it's got to be a prompt notice. Sometimes it says within a certain number of days. Sometimes it's got to be just, quote, reasonable. And so you need to look at that to make sure that if you're going to invoke a force majeure provision, you need to understand whether notice needs to be sent and the time by which it needs to be sent. Look to see whether the deadline is tied to the date it's sent or the date it's received. And then the form of notice can vary as well. Does it have to be sent by certified mail under the lease agreement? Can it be emailed? If it's got to be mailed, what's the mandated address for the recipient? Usually, if there is a notice provision, it's going to have to be written, but suppose there is a possibility that it doesn't require a written notice and other notice could be provided. Although you would want to confirm that with a written follow-up. The important part here is that if you if you don't send notice and there is a notice requirement, you can jeopardize your ability to invoke force majeure. And so you need to explore that. Next slide. So if there is no force majeure provision in your lease agreement and you have a desire to be excused from a lease obligation, one alternative argument under the law is what's considered what's called impossibility of performance. And this is a concept that's found in the Louisiana Civil Code. In Article 1873 of the Civil Code says that an obligor is not liable for his failure to perform when it is caused by a fortuitous event that makes performance impossible. Now, there's some exceptions to that, which are noted here on this slide under the Civil Code. But a fortuitous event under the Civil Code is defined as one that at the time the contract was made could not have been reasonably foreseen. So a lot of folks might say, well, we can argue that this COVID-19 situation was not reasonably foreseen when I signed the lease, and therefore this should apply. And it's possible that it does apply. We can look to some cases, though, to give us some indication as to whether it's likely to be applied. Next slide, Andre. Next slide, Andre. Oh, I'm sorry, we're back. One before that, two before it looks like. I'm sorry. There we go, right there. Thank you. So here's a sampling of a few cases where this impossibility of performance came into play. You can see that there's this West versus Central Louisiana limousine service case, which is a Third Circuit case, which is our circuit here, our appellate circuit in this area. And it says that the Civil Code article on impossibility of performance places a high standard on an obligor and calls for a common sense approach to alternatives which would satisfy its performance. And so that opens the door to some possibilities. However, we'll note on that case, it does say it's a high standard, so it's a high bar. The next case cited in the slide is from a Western District Federal Court, which is our district here in Lafayette as well. Sabre Industries versus Module. And it notes in that case that business downturns, economic impracticability, and strategic business decisions can be anticipated and to some extent controlled. Such commercial or business-related events and circumstances are not acts of nature, such as floods and hurricanes, and are in no way synonymous with an act of God. So in this particular situation with COVID-19, we've got a health crisis that is intertwined with an economic crisis. And so it's going to be an interesting question to see how the courts try to unravel that in light of some of this prior jurisprudence. This Eastern District, this U.S. Bank Corp Equipment Finance versus Lowe's case, which was 2008 out of the Eastern District of Louisiana, which is down in the New Orleans area, says that if performance is still possible in spite of the obstacle, the obligor must fulfill his obligation at any cost, whatever the sacrifice. Obligors are supposed to apply the totality of their resources, even to face ruin if necessary, in order to honor their promises. That's a really high standard to get out of an obligation under an agreement. There's one more case I wanted to mention too that's not on this slide, but it's called Mark Invest versus Moat Waynes America. It's a 1986 case out of New Orleans, and there was a lease, and the lease agreement said that the premises were to be used. The lease premises were to be used for the sale of T-shirts, gifts, and retail merchandise. And the city, the published case doesn't give us the background here, but for some reason the city prohibited the sale of T-shirts from these leased premises. And the city's use, and so the court evaluated that and said, does the prohibition against the sale of T-shirts create an impossibility situation for the tenant? And the court said that the city's use of police power was not a fortuitous event under the Civil Code, and that the tenant could have sold gifts and retail merchandise other than T-shirts. So as you can see, a lot of these cases do make it pretty difficult for an obligor, either a tenant or a landlord, to get out of obligations under the lease. But there is some ability to make an argument. Next slide, Andre. Real quickly, the last, if force majeure if there's no force majeure provision, And if impossibility of performance doesn't suit this particular situation, there are a couple of other possibilities to consider. One is a casualty provision in a lease agreement. That usually requires some kind of physical damage to the premises. And if there's not a casualty provision in the lease agreement, there is a Civil Code Article 2715 that says that if the premises, if the use is substantially impaired, then the tenant may be entitled to a diminution of rent or a dissolution of the lease, whichever is more appropriate under the circumstances. So that may be something that a tenant could potentially hang its hat on. The last slide I've got here is remedies. And so if one of these concepts applies, the question becomes, what's the recourse for a tenant or a landlord? And there's a few Civil Code articles under impossibility of performance that says if the entire performance becomes impossible, then the contract is dissolved, and it does give some obligations on the other party to perform to the extent he's already rendered performance. There's also a provision in 1877 of the Civil Code when performance is impossible in part, and it gives the court the discretion whether to require counter performance proportionally or to consider the contract null. And there are some other situations here under the Civil Code that you'll need to look at if a fortuitous event has occurred after the obligor has performed in part. If there is a force, so that's impossibility of performance under the Civil Code. A force majeure concept in the lease, it depends on the terms of the lease. Not all provisions excuse all performance or allow termination of the agreement. Some simply allow for a delay in performance. And my final note here is, in light of all this, be aware of the possibilities and the options that are out there. But because everything is so fact specific, and because there's a high burden to be able to succeed on one of these arguments, the best course of action is to try to find an amicable resolution between the parties. Try to find some way to work it out between the landlord and tenant if at all possible. And that's what David, my partners David and Andy are going to talk to, and so I'll hand it off to them.
Thank you, Kyle, and good morning, everyone. I'm Andy St. Romain, and along with David Kurth, we'll be talking to you about other terms of a lease, following the very good information that Kyle gave to you on force majeure. I primarily handle leases from the transactional side, and David more so on the litigation side and enforcement. So hopefully we'll be able to give you differing points of view. As I look at a lease, and I would encourage anyone who may have concerns that they pull out their lease and take a look at the terms of the lease. What I would be looking at right now would be terms relating to, of course, default, and whether a payment of rent or the non-payment of rent constitutes a default, and what notices or remedies apply. Likewise, extension provisions may actually invalidate an option for a tenant to extend the lease if there's an uncured default, and in particular, if there's a non-payment of rent. Late charges also, between landlords and tenants, start to talk about perhaps modifying rental payments, whether that late charge provision will apply. And somewhat related to this, and something that we'll talk about, are things like the ability to alter or modify the premises, and possibly rights of entry, which very often a landlord would reserve in a lease agreement, but perhaps under the circumstances and people trying to be quarantined, whether it's practical at all for landlords and tenants to expect entry into the premises. Also, you'll see a waiver provision in a lot of leases that provides for the failure of a landlord to insist upon strict performance of any of the terms, conditions, or covenants don't constitute and should not be considered as a waiver or relinquishment of that landlord's right to subsequently enforce a default, which could be material where spur of the moment or for a temporary amount of time, a landlord and tenant might choose to enter into other agreements to modify just for the temporary status that we're under right now. And relate to that, there's notice requirements, whether a notice has to be given. Often we've heard, I think, in the news where notices are by email, perhaps even a phone call, trying to adjust terms to contracts. And in that regard, look for leases to have some kind of a provision regarding the modification of the agreement. And in particular, where it says that the agreement can only be modified or altered by a written agreement between the parties, which would certainly apply if perhaps you had an email, or even less formal than that, if there was simply a phone call where maybe a landlord and a tenant tried to work out, at least for a temporary term, how much rent was going to be paid, if rent was going to be paid at all. David, what have you seen?
Well, a couple of things to point out. One is that right now, landlords may realistically realize that the chance of a tenant paying rent is slim because a lot of businesses are not operating right now. But you may still see a landlord serve a notice of default on the tenant. And the reason for that is because a lot of leases have provisions where landlord only has to send so many defaults within a 12-month period. And then after 2 or 3 notices of default, the default's deemed non-curable. So you may see a landlord sending a notice demanding the rent be paid right now in order to set up that argument down the road if once business resumes and we're back to life as usual, there are continued defaults. Something else to keep in mind with the notice of default is that different leases have different notice periods, so be sure to check your lease. And then another thing is attorney's fees. Most leases have attorney's fees provisions that allow the landlord to collect attorney's fees if he prevails. And a lot of leases don't require a court proceeding in order to collect attorney's fees. The giving of a notice of default starts the obligation for the tenant to pay attorney's fees. So tenants who receive demand letters very well may see that late charges and then also attorney's fees are included in that demand. So that's just something to be on the lookout for.
David. Andre, if you could move to the next slide, please. So I think the biggest concern for us today, or at least for this conversation, is rent, and of course, rent relief. What I've seen as recently as last week, the International Council of Shopping Centers, which some of you may know as ICSC, indicated that they expected as many as 1/3 of commercial tenants wouldn't pay their April rent. The terms that I've heard lately are deferral or abatement or rent reduction. And just to be clear that we understand the distinction, under a deferral, the tenant doesn't pay now, but they will have to pay later. And perhaps what they would do is have the amounts that they have not paid now amortized over future payments, as opposed to an abatement, which would be a forgiveness of all or a portion of the tenant's obligation for some number of, for 1 or more months. I've also seen hybrids of the two where there may be an abatement, but some proportionate amount of time added to the end of the lease. For instance, perhaps a tenant wouldn't pay rent for the next 2 months or April and May, but then at the end of the lease, the term would be extended for an additional 2 months so that the landlord would get the benefit of those rental payments. Also, I think a question that's going to come up for some is deposits, because I think very often, whether in commercial or residential leases, a deposit is part of the agreement. That's something else that I would recommend that both landlords and tenants refer to their lease agreements. I think that there may be a question as to whether the deposit can be applied for rent, and also if it were to be applied, I would be looking for a lease provision that calls for the tenant to then have to replenish whatever amount was used from the deposit, which again puts the tenant in the same position. David, what are you seeing?
Well, something to keep in mind with the deposit is that typically deposits are described as 1 month's worth of rent, but it's not to be used for rent. Typically, they have restrictions on that and specify that this is not to be deemed a prepayment of either the first month or last month's rent. So there are issues to consider, and again, look at the lease on whether the deposit can be used at this point to pay for some portion of the rent that's not being paid right now. And the other thing to keep in mind is that landlords are handling it differently. There are reports where some landlords have sent notices, and these are landlords with shopping centers throughout the country, have sent notices to all tenants saying, we expect you to pay rent right now, regardless of the shutdown. And then other landlords are sending notices to tenants saying they're working with them or they're forgiving some part of the rent or deferring it. So each landlord's handling things differently. So just don't expect some uniform approach, especially if you happen to be a tenant in multiple shopping centers, multiple locations with different landlords at each location.
So something else that I think is relevant, and I think we've heard it both in David's comments so far and Kyle's, is the impacts that lease amendments are having on different parties. Some things to keep in mind are guarantors. For instance, under our civil code, it provides that a guarantee could be extinguished to the extent that a guarantor is prejudiced to a change in terms. And whether that would be an extension to the rental term or perhaps a change in payments. So for anyone out there, particularly the landlord who's counting on a guarantor, that's something to keep in mind to the extent that lease amendments are being considered. And likewise for lenders, particularly for landlords who may have pledged to a lender their rental payments, a lender then would be a party or should be a party to any modifications of lease terms that might affect, in particular, the rent that's paid. I would also look toward management companies and whether they have a monthly fee, perhaps even collect the monthly rent to obtain their fee, to the extent that they may have a contract with the landlord that provides that they be a party to any modifications of the rental contract. And then, of course, between the landlord and the tenant, I think that with the landlord, there's concerns about their ability to satisfy debt service and possibly some liquidity ratios. But in particular for debt service, that a tenant, should they require any changes to the rental obligation, whether a landlord is in a position to actually work with them, regardless of if they want to. And of course, for the tenant, what I can see happening here is, of course, some tenants may not have the ability to pay or an impaired ability to pay. And in negotiating with the landlord, may be asked to make some concessions, which may be that the landlord asks for a guarantor if they didn't have one before, perhaps a larger amount guaranteed. Maybe there's an opportunity for a tenant to get an option to extend where the landlord instead now wants that option taken out. So definitely a give and take between the landlords and the tenant. In general, what I think we've talked about so far, David, is there's a lot of changes that could happen. There's a lot of provisions in leases, and I think we both need to pay attention to what we're seeing and how we have to react on the fly to what's going on these days.
And keep in mind that the landlord has obligations to the tenants, landlord has obligations to its lender. Landlord has obligations triggered perhaps by co-tenancy requirements and restrictions in leases with other tenants in the shopping center, which affects what sort of relief or options the landlord can provide to a different tenant. So there's a lot of pieces to the puzzle beyond just landlord and this individual tenant and trying to negotiate some sort of resolution or relief.
And in terms of all of this, I think we all have to keep in mind that our Louisiana Civil Code doesn't necessarily require that a lease even be in writing. But I think most people listening today, for the most part, whether it's a residential or commercial lease, would have a written agreement. And I would encourage everyone, as you are discussing terms between a landlord and a tenant, no matter how small it may seem, to put everything in writing. I often tell clients that the contract is there in case something goes wrong. You always know that you have something in writing to fall back on. And I would also caution people, particularly for landlords who may want to express to their tenants some well-intentioned expressions like, we understand what you're going through, we want to help you, these are extraordinary times. Just to be very careful, coupled with a phone conversation is something that could result in some unintended legal consequences. And then looking at particular documents, again, with respect to the lease, I would strongly encourage any amendments that they actually be written, that it not be in writing, even avoiding an email. Of course, an email would be better than a phone call, but very often a lease provision will say that it cannot be amended, or the lease terms cannot be amended without something in writing signed by the parties. In addition to the lease agreement itself, keep in mind that there may be people who have agreements that are reflected on a public record, particularly commercial leases where a notice of lease is recorded. And to the extent that an amendment may no longer match the terms of the notice of lease, a notice of an amendment to the lease should also be recorded to reflect those terms. David, I don't know if as far as writings go, if you have anything to add there.
Just real quick, both landlords and tenants should expect, to the extent there are writings, to document some agreement. It's probably going to happen often. I think landlords are more inclined to do it month by month because there's so much uncertainty of when things will end and life may get back to normal. So rather than doing a 3-month or 6-month agreement, landlords are going to, in my experience, going to be more likely to do a month at a time. So to the extent we're saying put it in writing, you can expect multiple writings as each month accrues, documenting the new agreement, assuming the landlord and tenant are able to reach an agreement.
Good point. And something else that I think we're talking about reactions in terms of what we put in writing. I think everyone should also keep in mind what we currently have in writing beyond just the lease. And in particular, subordination agreements where they may provide that the lender is not bound by any amendments or modifications of the lease without the lender's written consent. Perhaps even where the landlord and tenant would have warranted that they would not modify the lease without a lender consent, that could result in some defaults under a loan provision. And likewise, estoppel certificates, which both landlords and tenants may be asked to provide from time to time, those will often provide that a lease has not been modified or amended, perhaps that the lease represents the entire agreement between the parties and there are no other agreements written or oral, and sometimes even whether or not the lease has been guaranteed, and if it is, whether that lease is in full force. So it's, again, as if anything, take away that, keep in mind the importance of having things in writing, not only going forward, but considering what you have already put in writing, looking back as you consider amendments to documents. And then specifically to landlord and tenant, as you mentioned, Kyle, say certain performance obligations and whether or not they can be done. What I've seen in terms of what's going on now is holdings to say that one who rents a premises to another, knowing that the premises are infected with contagious disease germs which render them dangerous, without disclosing that fact to a tenant, is liable in damages for injury resulting from contracting of the disease by the tenant. Also, we fielded questions before about what a landlord should tell a tenant, particularly in the context of residential properties. I would encourage landlords, of course, not to identify to the extent a tenant may be known to have contracted the coronavirus, but also if a writing is required, maybe something to the effect that just reminding residential tenants that it's possible, even likely, that someone in a complex may have symptoms or be exposed, and encouraging everyone to take precautions until, and hopefully sometime soon, we are all back to normal. David, I'm not sure if you have had to field any questions like that.
We've looked at a couple of those issues actually, and the key there is not to identify the tenant, their privacy concerns, their possible HIPAA violations. So to the extent you have to, as a property owner, have to put your other tenants on notice that someone has been diagnosed with COVID-19, just leave it general. Don't get specific because you don't want to trigger other liability just by providing a notice to your tenants.
And I see that the next slide's been moved forward. Some other things that I think are impacts that are adjustments to operations that both landlords and tenants need to keep an eye on. Of course, percentage rent is going to change, I would say, over the last few months, where rent for some landlords and tenants is based on sales where there might be little to no sales, or perhaps a spike in online sales, or worse yet, a lot of returns from online sales where a lease didn't think in advance and adjust in-store sales for returns that are brought into the store from online sales. Also, again, and I think we heard this from Kyle, operating covenants, and whether, as to both landlord and tenant, perhaps the tenant has an obligation under a lease to operate, and likewise, a landlord could have an obligation to all of its tenants that all of the landlord's tenants would continue their operations so that they could benefit from traffic. And the same could apply for franchise agreements. I can see that also being an issue with operating covenants. And then something I think we've all seen recently, and I've heard it called a restaurant pivot, where now restaurants are serving only drive-through and not in dining. And in particular, for restaurants and for landlords, I think there's questions, one, about whether a drive-through is a prohibited use, whether or not the tenant can actually do it, and also beyond just the tenant's operations, whether a shopping center may have on its own underlying documents controlling the whole shopping center that may speak to and perhaps even prohibit drive-through services in restaurants. David, what would you be looking for?
Actually, those same things, because sometimes, particularly for a landlord, a lease with another tenant may prohibit the landlord from allowing any other tenants in the shopping center from operating a drive-through, for instance. So the landlord has to be cognizant not only of its lease with the particular tenant it's dealing with to allow, like the restaurant tenant with the drive-through, but also other tenants in the shopping center to make sure it's not breaching the lease with another tenant by allowing a drive-through. Also, insurance coverage may be an issue with the insurance coverage for the shopping center as a whole, or the restaurant that's making that shift. It's particularly if it's typically a dine-in restaurant now has a big tent in the parking lot with drive-through service and pickup and sending people around. That may not be covered by insurance, so that's something that both landlord and tenant need to keep an eye on.
Good points. And finally, I would also call to everyone's attention what I expect would be adjustments to the premises. We have seen recently where there's been a movement toward open offices to increase collaboration and teamwork, and that may be something that gets adjusted. And if so, tenants may be looking at their alteration and modification provisions of a lease, specifically with respect to altering the premises itself, and whether they can do it without the landlord consent, and to the extent they will, whether it's a structural change or simply a layout change. Also, I think common areas may be something else where we may see modifications. One, in terms of how many different people, for instance, in a break area may be allowed in a common area. And then beyond that, and from an economic standpoint, recall landlords not only are providing tenant space, but also common area space. And to the extent a tenant and landlord may talk about rent adjustments, whether it's only for the premises being exclusively rented to the tenant, or perhaps common area rented to that tenant and to others in a common area. So I would recap by saying, again, don't underestimate the value of communicating between the landlord and tenant and the documents that you have. Of course, be aware of terms of agreements you've entered into. No matter how small or accommodating it might seem, you should put everything in writing where you're amending the lease or modifying its terms. And again, encouraging everyone to really work together, because between landlords and tenants and all the leases that we have, it only works if we have landlords and tenants and they need each other. So I thank you for the time and hope everyone stays well, and happy to answer any questions. David, what would you like to add?
And Andy, and that, we can go to the next slide, Andre. One thing that we haven't touched on yet, and I'm sure a lot of people are curious about, is the eviction process and the status of legal proceedings in general right now. And there have been a lot of news reports in the past month or so that the governor has banned evictions statewide. I see a lot of quotes from people in the paper to that regard. As recently as this weekend, I saw quotes to that effect. And that's technically not correct. His most recent proclamation on April 2nd basically restated several prior proclamations and suspended deadlines in legal proceedings until April 30th of this year. Now, the suspension of deadlines does allow for certain matters to proceed in court in person. Those are usually domestic issues and child welfare issues. It also specifically allows parties to handle things remotely with the court by video conferencing or telephone if all parties agree to it. And it specifies that a landlord can retake possession of the space if the tenant has abandoned the premises. Abandonment is a factual issue, factual determination. Abandonment's the only time a landlord can exercise self-help in Louisiana. If the tenant hasn't abandoned the space and is still in it, the landlord has to go to the court and use the eviction process. But again, it didn't specifically say evictions are not allowed. Now, the Louisiana Supreme Court on April 6th, piggybacking off of the governor's recent proclamation, issued a new order that had replaced prior orders that affects operations at the court. And I'm sorry, that's the one that deems certain matters that can be handled in person and some by phone. But the Supreme Court's order specifically states that evictions cannot be handled by remote access. So on to the next slide. The practical effect of that is that right now evictions are not moving forward. You can, I think a landlord could probably file an eviction because the courts are open. They're not taking in-person filings, but you can mail things to the court, mail petitions to be filed. You can file them by fax. Some courts allow you to file electronically. So courts are open and taking filings. New suits are filed every day. But from a practical standpoint, evictions are not being heard right now. So there's no hearing in court. And we've done a survey of courts throughout the state to see how they're handling this because they have to set a hearing for the eviction trial. And it's really different on a court by court basis. Some courts are just setting hearings, hopefully far enough out so the social distancing orders will be lifted and they can have the hearing. Some courts are waiting until they know that all the orders are lifted and social distancing is no longer in effect. And then they'll start setting hearings. And other courts are doing it on a judge by judge basis and letting a judge make that decision. So there's no uniformity in that regard. And something else to keep in mind is that you have 6 to 8 weeks worth of hearings that have not taken place that have to be rescheduled. So the practical effect is any eviction trial is going to be, that can is going to get kicked down the road. And once the orders are lifted and courts resume normal operations, you're still going to be looking at several weeks at best before you have a hearing on your eviction trial. So with that, I will, and of course, we'll answer questions at the end of this. But with that, I will turn this over to Jim.
And I'll pop in real quick just to put up the contact information for the Jones Walker team and repeat the disclaimer that the information that's presented is general in nature, may not apply to your specific situation, and legal advice should be sought before taking action based on the information discussed. So thank you, Kyle, Andy, Dave. At this point, we're going to turn it over to Jim Keaty, founder and owner of Keaty Real Estate, which is a team of expert advisors and real estate consultants based in Lafayette. Jim is going to share some additional information, additional insights, including information on the current state of the real estate market in the area. After Jim's presentation, we will use the remaining time for Q&A with all of our panelists. So please continue to enter your questions into the Q&A box and select all panelists from the Ask menu. Jim, the floor is yours.
Andre, can you hear me?
Yes.
All right. All right. So, Kyle, thank you. Andy and David, some great information. Really appreciate your time this morning. And actually, I cannot see my slide. Andre, can you pull up my slides?
Yes. So I have your first slide showing now.
Okay, I might be having some technical difficulties here. I am not seeing it.
Well, if you cue me, I can just move at the appropriate time.
Okay, I'm not looking at my slides, so this might be a little bit challenging. Give me 1 second. Let me pull it up on my phone. I'm gonna, Andre, if you guys bear with me, I'm just gonna close out and then come right back in. Is that all right?
Yes.
All right.
And while we pause and wait for Jim to come back, maybe Kyle, is there one question you saw come through on the chatbot that we could get addressed by your team while we wait for Jim?
Sure, no problem. And Jim, just let us know when you're back online, and we'll take a hold on the questions. But there were a few good questions that have come in, Andre. One was and this was in the context of my presentation on force majeure provision in the lease. And it says, what does the carve out for rent mean? And what I mean by that is that a lot of times a force majeure provision in a lease will say that force majeure is available except for the payment of rent. So it does, oftentimes in a lease, it does not excuse the payment of rent, even if force majeure applies. But again, it's specific to a particular lease agreement and the provision written. So you've got to look at that provision. There's another question here that is, and it came in a little before David's comments on the eviction process in the courts and the status of the courts. And the question was, what does this mean now that since the courts are closed? And I think David addressed that. Maybe David, we could tie that one into how do landlords get their rent? And the questioner said it seems like the tenant will never make up their past due rent. They'll just move, and then they have nothing to show for it, or they have nothing to sue for, actually. So, any thoughts, sort of maybe a few summary points on the court process and what it might look like, and then also, the difficulties of getting rent from a tenant who may be in default on rent payments?
Yeah, let's keep in mind that there's actually two pieces to the puzzle. One is getting possession of the property, which is the eviction process, and the other is getting paid for the past due rent, which is an ordinary suit for breach of the lease. So, and those two cannot be combined because an eviction is designed to move as a summary proceeding. So it's designed to move on an accelerated basis. There's no, the answer requirements are different. Obligation of the tenant to file an answer to the rule to evict are different. The appeal delays are different. So there are two separate proceedings. So even if a tenant just moves out in June without paying rent, the landlord can still file a suit for the past due rent that is owed, up to the date the tenant moves out. And that's an ordinary proceeding. So it's got answer deadlines, it moves slower. There are longer appeal delays once a judgment's rendered. But the landlord has those two separate and distinct options. One is to evict and get possession of the space. The other is to file a suit for the rent that is due. So the landlord is not left high and dry if the tenant just moves out. And now it's a lawsuit, so it's a claim that you have to pursue and chase down. But you do have those remedies. And oftentimes, and we touched on this earlier, the lease has an attorney's fees provision allowing the landlord to recover attorney's fees. Typically, you'll have a late fee provision that tax late fees onto the past due rent. So there's some incentive for the landlord to pursue it. And frankly, the idea of avoiding late fees and attorney's fees is an incentive for the tenant to pay and get it resolved. So, and it looks like Jim's back if we want to go back to Jim and take up the rest of the questions later.
Yeah, you ready, Jim? I think your mute is on, Jim. There you go.
All right, thanks, guys. Sorry about that. I don't know what happened. All right, so Kyle, David, Annie, thank you guys so much for your time. Yeah, so I'm going to go through some tips for tenants and landlords. And one of the things that Kyle had said at the beginning, you know, really, it's real. The best case scenario is for everybody to try to work this out, so you don't need to hire David to go, you know, fight your lease in court. So, but before we get started, I want to start with go to the next slide, please, Andre.
Are you seeing?
I'm not seeing it. I'm having the, oh, there it is. Okay, so you can go to the next one. So we're going to run through the market. It's real hard for me to start any conversation right now without giving you a quick overview of what's happening in Lafayette. So just to give you an idea, we had the best record, the best first quarter that we had with 23% more dollar volume sold going into this crisis. Next slide. Okay, and then the average sales price increased by 5% year over year for the first quarter. Next slide.
Might be a delay with it coming through on your system, Jim.
Yeah, there it is. Sorry about that, guys. Please bear with me. Now, here's what is really interesting. So with, you know, to determine most of the closings that we had this last month in March were deals that we had put in place the last 30 to 60 days. And so when I want a good lead indicator to know like what's going to happen 90 days from now or 60 days from now is looking at our pendings. And you could see, you know, in March, the third week of March, that's right about, you know, between the second week and third week, that's right about when school was let out on March 16th, I believe. And we saw a significant decrease in the number of pendings. These are houses that we were putting under contract going into April. But one of the, you know, something that was surprising this week was we actually were only 20% off of where we were this time last year. And you got to remember last year was a record year for Lafayette Parish as far as dollar volume and number of homes and properties sold. So, you know, I was actually a little taken back. I'm not sure what's going on with the activity we had last week, putting houses under contract, but because we did have less showings. Next slide.
Just take a second to show up on your screen.
Okay. I'm having a.
Are you looking for the showings of the week from March through April?
Yeah. Well, so you can see by, you know, showing. So we use a system called Showing Time where all the realtors in Lafayette actually set up showings through Showing Time. And you can see we had a dramatic decrease in the number of showings going into March. The second week, again, around March 16th is when, you know, the schools were let out, and we saw that decrease, that trend continue into April. And we're at about almost last week was 68% less showings this year versus last year. Next slide.
The new listing slide is up now, Jim.
Okay, so one of the things we want to look out for, so we have lead indicators, our pendings, we have our showings, and then we also want to see, okay, how's our supply doing? You know, real estate's a function of supply and demand. So we want to look at all of those lead indicators, and you can see here our the new listings have actually decreased as well. And so not only is the foot traffic, the buyers decreasing, but so is the supply. So what we're getting here is less pressure on the home values to come down. So because our supply is falling as fast as our demand, you can go to the next slide. And I can't see the slides, Andre, so I'm just going to let you tell me what you got.
So this is the total inventory slide now.
Yeah, so total inventory, months of inventory is how we calculate where supply and demand is. At 6 months of inventory, that's where supply equals demand and prices are stable. What months of inventory means is if you were to stop listing another house today, how long would it take for us to sell out of the inventory that we have? At 6 months, supply equals demand, prices are stable. They're not going to go up, they're not going to go down. Anything above 6 months, there's too much supply and you're going to start to see pressure on the price to come down. Anything below 6 months, you're going to see pressure on the prices to go up. And you can see for the first quarter of the year, we were below 6 months of inventory. So we actually saw that price increase of $11,000 for the average sales price, which is about a 5% sales price increase year over year. Next slide, Andre. I can't see it, so just tell me what we got.
This is going to be the landlords versus renters, landlords and renters versus COVID slide, where you have the 4 boxes up.
Okay, yeah. So actually, Andre, I'm going to need to see this. So why don't y'all ask some more questions and I'll jump right back in. Let me see what I can do on my end. I'll pull it up on my phone.
Let us know when you're
go ahead and jump into the questions.
Sure. Just let us know when you're ready, Jim. So a lot of good questions coming in. Thanks for the questions. And I think that there's a little bit of a common theme coming through some of the questions. One is, what happens if there is no force majeure provision in the lease agreement? What is the remedy? And then there's also some questions about, legal recourse for landlords when tenants don't pay. And I guess I'll talk a little bit about both of those together. When there is no force majeure provision, then we talked about the impossibility of performance as a possible recourse under the law. It is difficult. It's a high bar. There's also the other civil code article 2715 relating to when use of the premises is adversely affected. Again, those are high bars to satisfy. I think that with regard to what the recourse ultimately is, it depends on every situation is going to be different. And some leases are going to be large scale commercial leases that have a high dollar amount for a monthly rent. And so there's a lot of financial investment in a lot of money at stake, I guess I should say. Other leases are going to be more in the residential sphere, are going to be a smaller amount of money at stake. And so those actually become difficult, particularly for landlords, because there are costs associated with the litigation process. One thing that what I would mention is, number one, landlord's recourse in this situation, like David was saying, is really no different than it is in an ordinary situation. The main difference is there may be a delay in getting that recourse through the court system, but you still have the same mechanisms under the law to assert a claim against a tenant. There's also mechanisms within some of our limited jurisdiction courts like small claims court, city court, those types of things that can provide some relief that may be less expensive than filing an eviction proceeding or a claim for lost rent proceeding in ordinary proceeding in a district court. So those are the things I think to keep in mind, is that there are some mechanisms in the legal system that are always there for landlords and for tenants, and it just may be that it takes a little longer to go through that process these days. Jim, are you back? Are you ready to roll?
Y'all keep going. One more second. I'm there.
Okay. Did you anything to add to that, David? Any thoughts on that?
To point out that you need to keep in mind that in Louisiana, it's against public policy to exercise self-help, and this is for landlords. So you'll see leases that that give the landlord the right, in the event of default by the tenant, to just go in and retake possession. Even though the lease says that, that's against public policy here. So as long as the tenant is in the space, you have to go through the courts and go through the eviction process to retake possession of the space. And if the tenant's moved out and the space is empty, there's probably an abandonment, but again, it's a fact-specific inquiry. One of the elements of abandonment is returning of the keys. Oftentimes that doesn't happen, but the space may otherwise be empty. But if there's furniture or merchandise, if it's a retail business, you err on the side of caution and follow the rule to evict. Also, keep in mind that some leases, and the law allows this, tend to waive the right to receive notice to vacate. But that doesn't give the landlord the right to just retake possession. The notice to vacate is step one, the eviction process. You send a notice and tell the tenant you're in default of the lease. You have X number of days to vacate, and that number of days is determined by the lease or by Louisiana law, depending on if the lease addresses it or not. And the tenant may waive the right to receive that notice, but waiving that notice is not a waiver of the right to actually go to court and be evicted by a court. So even if a notice to vacate is waived, the landlord still has to file a rule to evict and have an eviction trial and get a judgment of eviction if the landlord wants to retake possession of the space while the tenant's still there.
I think what we're seeing mostly right now, while these eviction and other court proceedings are being held up, what we are seeing are landlords and tenants coming together to work out a new arrangement. The landlord can use the future legal remedies available to it to maybe get a concession from the tenant. And David and Andy talked about this, whether it's a guarantee agreement from an individual, a promissory note could be executed for the amount of overdue rent, which makes it easier to enforce later. It could be a forbearance agreement where the tenant agrees to pay on an X date, and then you have a recourse on that. So there's a lot of different options that the parties have right now to try to work out an arrangement that can work, that may be easier to enforce than a formalized eviction proceeding later.
I think Jim is back on now, and I know we're running a little bit over time. So Jim, if you can see your slide, we'll get through your presentation, and then we might have time for one or two more questions before we wrap up. You might have to unmute yourself, Jim.
Can y'all hear me?
Yes.
All right. Sorry about that, guys. Had technical difficulties. So here's the reality right now. According to the National Multifamily Housing Council, 31% of renters did not pay their rent in April. That's up almost 20% from last month. Now, the renters that are living in federally subsidized affordable housing, they have a 120-day moratorium on evictions and late fees for for those renters. However, the landlords that have government-backed loans, they have a 90-day forbearance granted to them. So there is a little bit of a not unbalance there. Landlords are also, according to the Federal Financing Housing Authority, actually directed Fannie Mae and Freddie Mac to suspend all foreclosures and evictions for up to 60 days. Now, I have a few tips for what to do if you are a tenant right now and you're going through a hard time and you can't and you don't have the ability to pay your rent. The most important thing that you can do right now is communicate with your landlord. Pick up the phone, let them know what's happening. Even if you can't afford your rent today, but you think you might be in a bind in a month, you need to communicate that as soon as possible. Tip number 2 is apply for governmental assistance through unemployment, SBA, Economic Injury Disaster Program, or the grant program. Or if you're a independent contractor or sole proprietor, maybe the PPP. Tip number 3 is try to make your payment with a credit card and pay it back over time. A lot of landlords are accepting credit cards. There's new technology that is actually emerging through this crisis that is allowing more transactions to be done through credit card. Because most tenants are going to have to pay this money back anyway, you really should try to pay it if you can. Tip number 4 is ask your landlord if you can make partial payments or add 2 to 3 months to the back end of your lease, or apply for or try to apply your deposit towards a partial payment. But you have to work it out with your landlord. Ask your landlord to suspend late fees and interest or on any unpaid rent. You might get somebody might agree to waive your rent, but then they tack on extraordinary late fees or interest payments. So you want to be careful with that. So for the landlord, if you have a tenant, and I have multiple properties right now where my tenants are unable to make payments, you really just need to try to work it out. Number 1, the first tip, the first thing that I did was reach out to my banks, and I asked them if we had the option to, for lowering my payment, anything possible to get some relief there. I know some of my property owners and investors have gotten interest-only loans for the next, 30 days. So it's a really case-by-case basis. From what I've heard, some people are afraid to call their bank because they don't want to incur any late fees, or they're worried about their credit. From what I've been told from the banks, this should not affect your credit negatively. And so your best bet is it's better to ask if they will give you any kind of relief there. Tip number 2 is apply for deferment or forbearance. Tip number 3 is apply for the SBA Economic Injury Disaster Loan. And there's also the potential of getting up to $10,000 in forgivable debt, which we went over that in previous webinars. Tip number 4 is talk to your CPA about the carryback provision in the CARES Act. There is a carryback provision where any losses you could potentially put against any profitable years going back 2 years and even forward into through 2020. Tip number 5 is help your tenants. This is the most important tip. I think a lot of investors and owners they're not talking to their tenants enough, and you really should try to help them get help. A lot of tenants don't know what they should be doing. Don't assume that they know about all the programs out there that can actually assist them through this period. the more you help them, the more likely you're going to get paid. All right, next slide. Things to watch out for. We talked about this earlier. You want to be careful with hidden fees. Even though a lot of evictions aren't going to happen right now, you want to be careful because it doesn't prevent the landlord from evicting you. As Andy and David said, you can still be evicted, but it might not happen until the courts reopen. So be careful with that, and also be careful with incurring high late fees or interest fees. Over communicate with, step 2 is fraud and scams. There's a lot of fraud and scams going on right now. So I want to warn everybody, be very careful with who you're talking to over the phone. Some people are pretending to be the IRS or lenders to help you through this process. Be very careful on who you're talking and who you're giving money to. And it's a good rule of thumb, never give any money or any information out to anyone who is calling you. Always try to call them back. Make sure you're talking to the right person. Over communicate and accounting. We've been told that, if you do receive any relief whatsoever, you want to make sure you're accounting for all of the money. And then on top of that, I think Andy said it best. If you do get any relief from your landlord, you want to make sure it's in writing, no matter how small it is. You need to make sure you are accounting for everything, the money, and also any changes to your leases. Next slide. And I think that's what I have. I'd be glad to answer any questions you guys may have. I think Kyle said it best, though. You really should be working on communicating with your tenant and work something out. It doesn't do any good to argue or fight over something that the tenant really just doesn't have the money. Most people want to pay their rent right now, and they just can't.
All right, thank you, Jim, and thanks again to the team from Jones Walker. We are a little over time, but I know there have been a lot of good questions coming through, so maybe we'll take 1 or 2 of those questions, then we'll wrap up. And if we don't get to your question, I'll put my contact info up at the end, and you can email any questions we didn't get to, and we'll try to get you the answer as soon as we can. Kyle?
Thanks, Andre, and thanks, Jim, as well. It's been a pleasure presenting this with you. A lot of really good tips on there for everybody. I think we've covered the gist of most of the questions, Andre. The one issue that I see coming up quite a bit in the questions is related to the PPP and explaining what that is. And so I'll just do a real quick, very high level explanation of what the PPP is, because it's been referred to a few times throughout the presentation. We didn't go into it in detail. Like I said at the beginning, it's a federal program, and it's got a lot of aspects to it that would be too time consuming to address in this program. But PPP stands for Payroll Protection Program, and it's a federally funded program that is designed to protect payroll during this COVID-19 crisis. It was enacted by Congress in a very quick fashion, and therefore there was a lot of uncertainty when it was rolled out as to how it would work. And there were guidelines that were issued in very quick order. Guidelines changed almost overnight, and so the banks have been struggling with facilitating this program. It's administered through the Small Business Administration. And so, the best place to go, what I find is CPAs are very familiar with the PPP program, and they're helping a lot of their clients through that process. Lenders, some lenders are participating in the program, and the gist of it is that companies can get money, a certain amount of money, to fund payroll, but it does allow for a small portion of the funds to be used for rent, utilities, and other business expenses, some limited business expenses. I think the maximum is 25% of the amount awarded. It's companies can get some of these funds, but also some like Jim said, independent contractors and sole proprietors can also apply for it. So you can't get it. We're talking here about leases today. You can't get the get PPP funds for rental payments themselves, but if you have payroll that can be used, that can be used to fund the PPP grant, it can be forgiven if you have, and you can use a certain portion of it for rent payments, and it's a forgivable loan from the federal government. So, speak to, I don't know if Andre, if one of Acadiana has resources on that particular program. Jim also mentioned the EIDL program and the grant associated with it, which is important too. And so I'm sure there's probably been webinars. Has one of Acadiana done a webinar on that, Andre, or do you have resources?
Yes, so we've done a couple webinars on those programs already, and we have put together what we call an economic recovery toolkit that has information on the Paycheck Protection Program, the economic injury disaster loans, and other tax credit programs that are available. So we'll make sure to get that out with the follow-up materials. Also, just a quick point too, we're encouraging everyone to talk to their banks, talk to their lenders about applying for the Paycheck Protection Program. Independent contractors and self-employed individuals are eligible to apply now as well as of Friday. So if you have tenants who are self-employed, independent contractors who are struggling to come up with their payments, they may be eligible now for PPP forgivable loans to pay themselves. And once again, we encourage them to talk to their bank or their lender to see if they're eligible and how to navigate that program. And with that, I think that brings us to the end of today's presentation. Once again, want to thank all of our presenters, the team at Jones Walker, Kyle, Andy, and David, as well as Jim Keaty with Keaty Real Estate. We really appreciate the information you were able to share with us today. If anyone has questions that we were not able to get to, please do email me. My email address is on the slide now, andre@oneacadiana.org. And I'll work with our panelists to try to get you the answer as soon as we can. We're also going to be posting the video and slide deck from today's presentation and emailing it to all participants within the next 24 hours. Sometimes it takes a little while for the video to be generated, but by tomorrow morning, we should have the video recording and slide deck information out to you so you can access those materials, and our partners who partnered with us on today's webinar will be sharing those as well. So once again, thank you all very much. This concludes today's webinar. Please stay safe.
Thank you.